affidavit, file affidavit by the railways. Till date, we have not received anything, but I do not know.
Where is Mr. Parry?
Just now I have received.
Just now you have received. Your junior has received.
Just now I have received.
I'm giving this hard copy just now to the petitioner. This case. Because the additional affidavit was prepared yesterday also. Then I saw the copy.
Right on the last day. That is what I find is a recurring phenomenon everywhere. This court is not spared.
That's the reason.
When the order was passed long back, and there was a direction on your prayer, it was there. It was done on
31/3 also.
31/3. Then why not? At least 2 days before.
Yes.
Last night. And serving today when the matter is taken up and for final disposal.
They are also served just now.
Also, only those documents will be presented.
Sir, this is what is implementing the delay in disposal of the.
Apologetic for that. I'm apologetic. Extremely.
Whenever the next date is coming, 1 day before, everything is done in haste and then service in the court.
I'm apologetic.
But at least 2 days before, give them an advance copy.
I will beg that
Give them an advance copy. About it today.
for intervening vacation. I could not do that.
Intervening vacation means.
It has to be upload, downloaded, and everything. So I'm sorry. I don't beg me excuse you. Also for that, I'm sorry.
Pursuant to the Tuesday is holiday. 21st.
I understand, Lord, the undertaking given will continue because
Yes, yes.
That will continue. There is no difficulty. We have
It's the last day.
Oh, yes, sir, it will continue.
I'm great.
May I just bring to your lordship's notice this, Lord? On the last date, when the matter was taken up by your lordship had said the interim order is not extended and we will file an affidavit. Now, what I find from the affidavit which has been filed, your lordship, that is why I wanted to make a submission to your lordship. The affidavit which has been filed does not bring on record the documents that we have filed.
But kindly see what
That
is
is what
happening.
is there. Why you are taken advantage at the time of an argument that they have not disclosed those documents. That is what we'll see. If there is a suppression by them. Adverse presumption under section 114 of the old Evidence Act will be done. Adverse influence can be done.
We'll see full tender. Adverse influence against me will harm me, my lord.
I do not know.
And we have already placed purchase orders, my lord, pursuant to the.
They have given undertaking that they are not going to do anything. That is what an undertaking is given to them.
My lord, before that, my lord.
If something is done, they have said we are not going to proceed any further. That's an undertaking which was given.
It was not exact. My lord, last
Same things are when counsel, a responsible member comes and tells to the court, we have to take cognizance of that. We can't. If we defies, we know how to deal with this.
Problems are huge.
your lordship may kindly see the last order.
The problem is I would have placed it on 14th. It's a holiday. That's why I'm placing it on 21st.
Your lordship may see the last order. There is no
The stand
extension
of
of
the
the.
railways and
The interim order was not there. This is an undertaking which is given. That is there.
It was
records
not
that, Lord.
that interim undertaking was not extended.
Lord, kindly records that.
It
Lord,
is automatic.
This is the stand. If this is the stand,
Your
Lord,
lordship,
kindly record.
The assurance given before shall continue till the next date.
Grateful, Lord.
In that case, can I request?
Your lordship, in that case, your lordship may take it up day after tomorrow or some other day because it's causing us great prejudice. My
No
lord.
difficulty. Day after tomorrow you want?
Yes, my lord.
Do
Day
it.
after tomorrow.
Do
Day
it.
after to take it up.
Do it.
After tomorrow is? 16.
Thursday.
No, 16. I'm so sorry.
No, do it.
Nine.
No difficulty.
Yeah, sir.
I am really, do it.
Yeah, sir.
Yes, Mr. Mukherjee?
I'm fine with it.
Yes. I am also okay with that.
I only pray that your lordship may afford me an opportunity on that day. Because
And I can't assure you.
That your lordship normally assures. That
No.
never, your lordship never deny that. Equally to me also.
because what is happening is,
Who will be there, I don't know. How can I?
My lord, your lordship may not be there in that case. Oh, your lordship is going on leave. That's the reason. Okay.
sorry, sir, in that. But I was not conscious of that. I was not conscious of that.
So that is why I was not saying
At your lordship,
I was
earliest convenience. I will rephrase my
That is
submission.
why I
At
was-
your lordship, earliest convenience.
I was keeping silent. I was just trying to read why your lordship is.
I was not aware of that. I was not aware of that. Hence, my lord, say, rephrase my prayer at your lordship's earliest convenience.
13.
21st.
Continue what?
I am not suggesting any date, not your lordship convenience.
21st.
Madam,
Obliged.
list item number 1.
I'll not fall in the trap.
Your Lordship, have some mentoring to do. Have some mentoring to do on the two matters. Has been filed on.
Mr. Patsai, I will allow you.
Whatever, you want to argue or not?
But we will second round of litigation. The first round, the petitioner has claimed to this honorable court to extend the lease period by amending the lease date for the period for which he was not allowed to work. The writ petition was dismissed, and
That's the order we have already said that in terms of 64.
Yes,
Consider it.
that's it, sir. Can you- I will only pay this one.
Has it been?
That's it.
यही मैटर रहेगा
Person-
वही था
Asanta has been, this is.
That's it. That's it. Yes, that's the time down to page 108 million. His representation is
So I can't come to the 108.
No,
That you can do it, my brother can do it, I can't.
Millet, only to show Millet. This is dated 13/3/2016. And this writ petition is filed on 16/3/2016.
What?
That will carry down to page
Sir, I
115.
can't read a bit of petition. I think my brother will. Oh, 16 is the.
This representation, it is dated 13/3/2026.
16, that's it.
That's why I am also surprised. That's why. So why don't you dispose of? We have already directed the light of those provisions. Take a conscious decision.
And writ petition is filed on 16/3 Millet, only 3 days ago. That's I read.
No, I got it. That where is the order? There is already. Yes.
Annex 12 is the order passed by your lordship.
No, not this one. No.
Annex 12, let's say.
Sorry.
Madam,
Not get. Prashanto, there is also. What are you talking? Report.
64.
Report.
Refund, yes, are you listening refund?
Prasad, and my prayer is to allow, apply rule 64 and extend.
Ah,
No, whatever. Let them take a decision in this. No, there is another option.
No.
From this.
But I'll.
that's what I. First,
mobile option.
64.
This is a good thing. This is a good thing.
No, there are.
Since we are already in a contemplation of this aspect, 12B has been declared as ultra virus. So we have already heard. We are in contemplation of deciding the same. Let it stand over till 21st. And notice to the Advocate General. Yes. If the virus of Rule 12E you are invoking a force majeure clause.
No.
He's seeking an exemption.
Exemption, but it is 25%. During that period, you could not.
Yes, sir, because
Why?
because the election 4 was issued with the direction that post office pays 50 or so.
Now, what is the reason you could not carry out the operation?
Election 4 restriction was imposed. Immediately thereafter, I have also made the recommendation.
What happened after 15th October?
15th October he is allowed. Thereafter, my lord, since January 2026,
And from January to March, what is this?
January to March, my lord, in fact, the mining officer who was holding the post, my lord, there are some allegations against him, he was transferred. So no transit pass was issued to in favor of the petitioner. That is my specific grievance. I have also mentioned the same in my recommendation. That is pending before.
Why are you not taking consideration of that?
Yes,
he has raised a genuine
Yes,
remarks.
Let
There is a period by which you have suspended the
Yes,
operation.
he
How
has
can you
a-
collect the rent from
Yes.
your own act.
Yes, my lord. Let him approach, my lord. He has a case, my lord. Let the authority take a decision. He
Where
has,
is the approach?
my lord,
Approach
that,
Annexure 8, my lord.
my lord, let him give a fresh one, my lord, because
But
this is,
then this July to October part is not covered in the.
no.
Only they have.
Only transit pass.
Yes, let him give a fresh representation.
Yes, sir. Okay. Yes, sir. Now, the petitioner has Oh, sorry. Necessary also. No course answer because they have already issued the demand notice. That
demand notice predates their grievance mill. The matter will see. That is the old demand notice mill. That is the
for this period.
yes. Let them. We are not taking any action. Let them approach.
Before I take a lot, it will be very specific that demand and challenge here. In fact, the demand was challenged before the regional authority or the settlement. That regional order is unacceptable. But inadvertently that missed out from there. I have applied for amendment of the request. That is IA number.
Have you served?
Copies have been served here. I have also applied
Is there an order on rule 10 for addition?
No, this is order 16 rule 17.
Order
We have also applied for Complete Union of India as a part. There are two applications. 5900. 5900.
have you got?
Yes.
What do you say? Is a completely a new get-up of the reproduction or
No.
it is really? I mean,
So 12 is there.
I'm asking a pertinent question of law to him.
I'm so sorry.
Let him say, if it is a completely new get-up, you have some demands. You have some point.
Because they want to challenge that particular annexure issued order passed by the regional authorities. In fact, by
Subsequent to the filing of the writ petition or during the or before the filing of
that order was enclosed to the writ petition, but somehow in the prayer portion it was not challenged.
Okay, that is what the necessary pleading relating to that challenging the order is already there.
But they wanted to take advantage of that order to file the writ petition before this honorable court. Because that order said that we are not the competent authority to entertain the revision. You may approach the appropriate court. That is why they filed the writ petition. Now they want to challenge that order because that order has been issued by a section officer, not by the revisional authority. A section officer of the revisional authority, not by the revisional authority. Because a section.
They want to take advantage of it.
Yes, they wanted to take advantage of it.
That means according to you, they are resigning from their own stand.
Yes. Yes, they are resigning, but even if that
Tell
issue
me where they have resigned. If that is the fact, Mr. Rob, then
I don't decide. We have brought it to the notice of the honorable court about that order. We have not accepted that order. Kindly see.
that is what I really invite is the attention, Mr.
Annexure 12 is the relevant.
No, we sir.
Right, Lord.
12 is something you.
That is very foundational aspect of amendment. My Lord, Lordship has asked the right pertinent question. Kindly see. Annexure 12. We don't accept the
No, pleading relating to annexure 2.
page 20.
We are concerned with the pleading, not the annexure, sir.
No, not reading. Annexure page, para 24. 24. Good. In fact, we are challenging that order in para 25.
then 25. It says furthermore,
Not accepting. That's the
action
unless
is
sufficient.
not considered is also
Kindly see para 20.
under so and so that the petitioner being left with no alternative efficacious remedy is constrained to.
No, he has said that though there is a revised, the remedy is by way of a revision under section 30. Yes. But the petitioner is challenging because you are not considering the representation in the proper manner. That is what it appears from.
Reading.
And they sought for a direction to decide that particular representation.
There is the demand notice, they had filed a revision.
True.
Yes.
So there is no difficulty if they have also explored or exhausted the remedy, then If something not work, then they can challenge that order. This is really what is the date of the order? Original of
17th May 2023.
and when the petition is filed, it is for 8th, sir.
23, sir.
Judgment will relate back to the date of
Date of
petition. No. This is an application.
On number 5, may I please your lordship? May I please your lordship? On behalf of Ms. Sarawara Jana, I prefer an adjournment, lordship.
Adjournment till 21st.
Let's-
Item number 6.
Regarding the refund of the amount when the operating the Swajar source. That's from consumption is same cost in matter. Another Swajar source has been decided matter.
In this matter, we are filing counter affidavit today. Many factual aspects are there. We are filing today. It is submitted by the learned the adjournment 21st
Item number 8.
on the pair. Huh?
I've received similar instructions, but in case of parallel comment, the bulky look at something or to file. I shall be with it.
Was it directed for the council appeal, the learned AG appearing for the Twenty-first.
Item number 10.
Yes, in support of the writ petition, 21st.
Item number 10.
10 minutes I received the counter yesterday.
The counsel for the petition.
Item 11.
Number 11 is also Kartakalam directly the stress of the interception. So when some more time, I will let out of this. Some more time.
Yes.
So much time.
Who is on VC?
No, this is over there. I am actually. Also, it is to open number 3. No, number 3. You
Oh, this was a very interesting point. The senior advocate raised. Taking aid of certain provisions of the Act which permits the continuance of the lease up to 50 years.
50 years. 86.
It's a pure question of law, sir. It's a pure question of law.
No, so instruction is required because the order itself, the original proceeding. So there is some difference. Whether it has already last or not, that's
Because by virtue of this particular amendment having brought,
yeah.
I know there are certain leases which were operative till 2020 and some 2030. But thereafter, the auction regime, when it has come, that has to be taken care of. These are the pure question of law. What you you can argue this matter.
169 of the proceeding itself. That's a spectral difference. They say the Royal Council submit that the lease was extended for 20 years. But it says that it's not 10 years.
But 10 years?
10 years.
10 years?
With an option for?
No. What has happened, High Court interfered.
Oh, acha. The High Court has said it should be deemed. Yes.
But in fact, the state government did not grant. The High Court order was not.
Now I recollect that I kept mum. I did not make any observation.
They neither challenge. And
You know the law better.
so
You know the law better.
Here.
So I'm not making any comment.
Has asked me to read the Pravas Dulai. I have already read.
Pravas Dulai judgment you have read.
I have read.
It is
Para
makes
14
a
I have read.
distinction between a renewal and extension.
Extension, para 14. I have read para 14, and your lordship has also been followed it in that Chhataj case. That also that I have read. That Chhataj that I have read.
The wrong proposition of law.
No. But here in my case.
No, I'm asking something else. You are avoiding.
It's not. It's not. But it's not. It's not because rather your lordship has gone to renew all these things. So all these things, in fact, I have not read that. Earlier also I have confessed I have not read that. So and this is what after reading and Gajraj Singh your lordship has followed. So all this everything your lordship has given a very enumerative, it's a lucid judgment. But at my age it is not because it is.
What your juniors are doing?
They should read.
What the your juniors are doing?
They should read. I'm
They should ably assist.
Yes. So they have taken down. And Millard, what is here? Here a very short point.
I know that.
They are asking from 1971. There is no 71 date. And it is here 91. 91 I have shown the document that with effect from 91. That is Raman has seen that.
That is what I invited your attention because they say that 91 is a renewal. That's why I say that what is the meaning of the word renewal?
Yes,
it does it contemplate the previous period to be counted, or it will be a fresh. It will be deemed to be a fresh lease. If it is deemed to be a fresh lease, in view of this, then it will be an original lease. Whatever earlier happened has happened. He has gone.
Another 50.
And here it is extinguished. Here is also
and in the case of an extension, you stands on a better footing.
Yes. Had it been extension because in Pravas Dulai, there
is this flow from the original.
No, in Pravas
Dulai from the original.
Pravas Dulai, there was provision for extension. 1 year, 2 year, like this. But here it is not like that. So that is how here they have to 71 is a wrong. The revisional order has only based on 71, a very cryptic order.
I have seen, sir. That's why I'm inviting his attention to that. That's a pure question of law. It does not invite any factual aspect.
Yes, your
facts are admitted.
Yes.
Let us see on this admitted fact what law says. That is what, sir, I really wanted. And that's why I'm impressing upon him what more. Factual aspects are not disputed.
Are disputed. That means
the only thing is, will it be counted from 71 or will it be counted from 91? That's the only question. Both leases are there.
No, 71, there is no lease. That's a wrong thing. There is no lease. That is what I want to show.
No lease.
What has happened? 43 to 63 it was given. Thereafter, 43 to 63.
For 1942,
43 to 63, given for 20
years.
20 years. Thereafter, it was gone to the sale, and it was reserved for the public sector. And Steel Authority of India, he has taken the lead. Then he surrendered in 1986. Thereafter, in 1994, it was renewed with effect from 91.
The That is what I was thinking, renewed or in that sense.
That is a phrase. That is not even in circumstance, that is also a phrase.
You also see the factual aspect what is written in the order.
Authority of India
In surrenders.
surrenders.
Yes.
94.
No, 86.
86.
Yes.
Then in 1990.
Then 94,
With the retrospective operation from 1991.
Yes, my lord has
So that is
remembered
fresh-
it correctly.
Fresh lease from 1991.
Yes, no, he stated as renewed.
Now, what he was, Mr. Swai was interested in, that another company was,
Yeah.
and you are the,
No,
that is what.
no.
Everything will be clear if your lordship will come to page 168, that is the interim order itself.
Millard,
Page
that order is wrong.
That order is actual.
Is that wrongly? He
Yes,
has
that-
assumed the wrong.
Millard, can I read Millard only one page, let him before that, your lordship can turn to 120 page.
Let me place it there.
No, page 120, then your lordship will find out.
Me to place.
120. Just Millard 120, your lordship. Whole Millard, the case history was given here by the RCCF who was recommended in my favor for the first clearance. Millard, may I read, Millard? The brief description in para 1. Your lordship kindly see. Para 1.
Yes, lease period from
Then manganese ore such and such, and such and such, then the signature was here. By H. Dhanjit Kumar.
Yes. Pandya, with validity of
Period from 1943 to
63, as I have told my lord. Then subsequently,
subsequently, this
Sri Dev Kumar Pandya, wife of Dev
Dhanjit, who
Gandhi
died.
Kumar, has applied for HARISH in 1968.
RML means renewal.
Renewal of mining lease. That was
68.
applied 68. The lease was not considered in our favor and
And it was
it
granted.
was granted in favor of sale.
The lease deed was
The
executed in
lease deed was
79.
executed on 28/79, but sale
But surrendered in 1984.
84, which was
Accepted by the
government on
government.
86.
Yeah.
Thereafter, Millard, kindly come to Millard, the
Then the writ petition was filed by that, the widow.
widow, then
And then in such
It
and such
was-
directed the state government to dispose of the renewal application.
yes,
Subsequently, the granted the working permission
yes,
by handing over the position.
yes.
Who working,
Granted working permission, video
who,
by handing over position
to who?
to Dev Kumar. Pandya.
Dev Kumar.
Yes,
Yes.
10 years for that position. The lease deed was
For
executed.
10 years from the date of the position.
Yes. Then the
lease
lease deed
was
was
executed in 96.
Millard, here your lordship
Was to expire in
left date.
I'm there conscious.
Ninth month, yes.
I'm very fast in reading.
Yes,
So
Lease
it
deed
was
was
to expire 2001.
period from
Then
91
then
to
the matter came before this court.
Yes.
This court says it will be extended to 20 years. Deed will
Yes.
be extended.
yes,
So it will be a lease for 20 years.
yes.
So that expires in 2011.
No, Millard, no, your lordship can see subsequently the lease was transferred to Zenith. Then I come, Millard. Here the Zenith is the petitioner.
Yes.
So Zenith Private Limited.
So
From Dev Kumar.
sir, you step into the shoes of the original lessor.
Yes.
There is no difficulty.
Yes,
So we have to
what he
grant it.
said that to another person, to another
No.
person.
From 91.
So you are bound by that 91 lease.
Yes.
There is no difficulty.
Yes,
So it was operative till 2011, sir. Let us see.
yes. Subsequently, the lease was transferred to Zenith and by Dev Kumar, and transfer deed in favor of Zenith was executed on 13/8/98 over the so acres or revived with 35 after the exclusion of forest area.
Anyhow, the High Court interpreted section 8(2) of the MMDR.
Yes. Then
and then
in
they
that
extended
paragraph,
the lease from 10 years to 20 years.
yes, then in that paragraph, your lordship can see, however, the last two lines, however, the state government has not taken any action on the order of the Honorable High Court till date. That paragraph, last two lines.
Consider the application. of the lessee.
Yes. Then project proponent has applied for grant of renewal on 2000, sitting at 10 years. Then 1 year prior to expiry of lease period, hence the lease is under the deemed extension provision. That is 24A6 of the Mineral Concession Rules 1960.
So that is what is the. It's the order one. But the timeline has, we wanted 20 years.
That was 55.
Now says it is 50 years.
So that's why we have placed 1 year time.
And here we are, can you see 32, page 32? Page 32. Paragraph 3. The Land Council of State Government states that the lease was granted on 23/10/71. There is no date 71. And as for section 8A6 of MMDR Amendment Act, it was already completed 50 years from 2210. This is wrong. And therefore, even if there is any impairment in the proceeding, the lease cannot be revived because it has already completed 50 years. He states that the leaseholder
It's only contention
required.
whether it will be.
The question is whether there was a lease or not.
71, there is no lease here.
According to him, there is no lease in 1971. But my specific stand is there was a lease or
a bit further.
Yes.
Please, I am going a bit further.
Yes.
Suppose there is a lease of 70. But in view of this subsequent events that has come,
Yes.
when a fresh lease for renewal has already been executed, whether
It will continue.
previous lease will be treated to continue, or it has been superseded, or
Exactly. That's the
it's
question
a
of
fresh
now
lease
with regard to
from
that.
1991,
With regard-
and then you have to consider the period.
Yes.
That's the only one.
Yes, that with regard to that, I will often.
Now tell me whether 71 is the correct
Yes,
proposition
yes.
in view of this admitted facts by your authority, or it is to be counted from 91. That's the only question.
Yes.
I pay only.
Let us see, there was a 71 lease.
Yes.
You cannot deny in 1991 there was a fresh lease which was done. 96 retrospective effect from 91, whatever.
Yes.
Let us start that the lease commenced from 91. Then the tenure has to be decided. In their case, the court has held that it has to go to 20 years. There's a fresh lease. Now, virtue of an intervention of the act, if it is to be, it has to run
50 years.
50 years. Then why?
There are several other matters.
Page 117.
in the original.
Page 117. This court's judgment in 2009.
Yes.
You find a counter. I think if you have not objected, then you have not brought forth any lease of 1971. That's the same.
Ma, there are several points are raised with no.
So that in the judgment where 20 years was directed.
Ma, there are several other points are also raised before in the original proceeding. In the original proceeding, it has page 160.
Sir, I'm now
And
putting a question to you.
the regional authority only took up only one side.
I'm putting a question to you, sir.
Yes.
On a proposition of
I don't have any quarrel over that.
what?
Extension or removal.
No,
on
I'm
that.
putting a question to you.
Yes.
Have a patience. There was a litigation between the two parties earlier.
Yes.
In such litigation, a specific stand is taken that the lease was executed in 1996 to commence from 1991. The court recorded the submissions of both sides and said that it is a 1996 lease, 1991 it commenced. Can an authority say that it has not started in 1991 but in 1971? Are you not bound by the decision of the court between the same parties?
So my submission is that
Can you defy, authorities can defy the sanctity of the court's observation?
I have two submissions.
Contrary to what the court has said
The whole
judgment.
The whole thing is the original proceeding out of which the revisional impugned before the revisional authority, that order itself speaks something different picture altogether. And many
Sir, I am again, sir, asking a pure question of law. Sir,
That-
you are
that-
an officer of the court.
that-
If, let us see, the lease may have commenced in 1971. Let us proceed a worst case. Let us proceed. Yes, it was a 1971 lease.
And every part of the performance with
There
that.
was a litigation between the parties, same parties. In the judgment rendered by the court has said, no, it is 1991. Can a defeating party continue to take his stand that it is 71? What is the sanctity of the court's observation?
That is why I admit I don't have quarrel on that.
Can you go beyond that?
No, but factually,
That was there. Then I am reminding you of explanation 4 to section 11. A point which was available to you ought to have been taken in an earlier litigation, having not taken, shall be deemed to have been taken therein and decided by.
With regard to legal profession,
I believe, sir, I am correct. Understanding?
Yes, that's the logic.
Explanation 4, sir?
Yes, that's.
Milord, your lordships,
With regard to legal profession, I don't have.
your lordships, the legal acumen, it is unparalleled.
No,
So, I don't have any. With regard to profession of law, I don't have any quarrel on that note. Only the
What is quarrel then?
that's the factual.
Factual. 71, 96, that door is closed.
After some time be granted without an instruction, can it be disposed upon that?
This is something.
Only
Yeah.
now it is not
Actually, that's my, I would say,
lease is not
weakness.
operating since
That's my
2010.
weakness always, because I feel that fullest opportunity should be given to a
Yeah.
member of the bar, because he should not go back with some kind of a resentment in his heart that I was not able to submit
Respect.
fully. But this is being taken as a bonanza for some.
No, it is only
seeking an
that's
adjournment.
wrong. It is only
It is really taken as a bonanza for an adjournment.
without taking instruction, if you occupy because of the matter.
Sir, with folded hands, you are representing the government.
Yeah.
If the pure question of law is involved,
So, yes,
will the
factual-
authority tell you, advise you what is a law? Or what is your role as an officer of the court? On proposition of law, you will argue. Factual dispute, certainly you need an instruction.
I have to check also factual aspect. What is submitting that night?
Sir, I am giving you that your authority has said 71, 50 years expired. I am asking if the Zenith judgment, that's his case, the court has taken this plea and proceeded on the basis of 96 lease. Can you take a plea of 71? Why not? Res judicata explanation 4 will also apply, because that was available to you when that matter came. You did not.
You have taken that.
Where is that? Sir, I do not find from the judgment.
The judgment said
If it is taken, let us see if it is taken. If the court did not accept.
No, para 6.
Can you say the interim order itself? The interim order itself.
Para 6. Come to para 6 of that guy.
The divisional court judgment. The divisional.
No. Judgment of this court in division bench.
115.
Para 6.
Again.
Para 6, sir.
On the direction of this one, basically, the permission.
You have produced records.
Yes.
Court perused the record observation is at para 2, that 91 factor is stated therein. How can you dispute at this juncture that judgment stays at us? We have not challenged it.
Stays at him as well. He was a party there. Another post.
Before this bench,
Yes.
we can say this bench.
Even to them. Even to them.
No, with that I don't know.
Then what is the quarrel?
Whatever Vastu comes in, it's not often.
Para 2 observation that
Yes.
case of the petitioner is that pinches.
Sir, with deepest of humility and the respect to his command, granting him a time he is not prepared, John. Please pardon my impertinence in observing this. It appears that he is not prepared. Despite last occasion we have expressed, now you have come prepared on the basis thereof. He has not gone. He has not gone into those aspects. He has not read the file, not as husband.
I will.
Your notice is extra.
I will enclose the order of the order. Yes.
Today I am not accustomed with the extra copy theory or a notion, but because
Take it from the.
Yes, LMS.
Yeah, LMS.
Instead of sending it through.
Item I free may be taken up on 21st because I have received various documents and certified of an affidavit. Lots of it.
you want to file affidavit, there is a affidavit? No.
No.
File affidavit by 2 weeks, with rejoinder by 1 week, 3 weeks.
Item number 13.
Some pages in the annexes, some pages in the annexes are wrongly marked and wrongly placed. So my,
What do you want?
I pray for withdrawal to liberty to file.
The counsel for the research.
Item 14. Item 14.
Interesting point, whether the rule 33 of the OMMC rule can be simultaneously invoked along with rule 3319. According to you, both stand on a different footing and invite a different
And the last hearing, they have handed over me the termination letter. I've got the.
Oh, you have filed the amendment?
Yes, sir. And short note.
Let's see. Amendment is not allowed.
No, we have, because they have terminated the problem. So now we wanted to challenge the termination.
I'm sorry, that question.
Already.
Where is the application for amendment?
Like me, man. One pay one. Three plus one. You did.
So, this is. When date 21st.
Yes.
Yes.
Item
Who is
number
appearing for the other side? This party. You are. It's 21st. Thanks.
item 15.
That should kindly pass on to the.
Come on, 21st.
Item 16.
Then item number 16, there are some major errors in the annexure. So what I pray is, I will permit to withdraw this liberty.
Same order.
Yes.
Not a different
Memo. Item 7. Item 17. Sir. Item number 18.
Item number 18, if you are going to go for petition.
Because uses the word deck. You have a right to appear both under the constitution and the statutes.
Absolutely.
Well, just colonial expression.
No, just my.
When I'm appearing for the solicitor, that's not.
Just to do a brief recapitulation as to what had happened on 17th of February. A point was raised before your lordships that whether
acceptance of a false affidavit.
Acceptance of a false affidavit and non-disclosure of pendency of a criminal case where illegal mining has been assessed to the extent of rupees 200 crores will fall under the dues in terms of Rule 27 who are used. My lord, the petitioner H2 bidder.
No, I understand.
H2 bidder, my lord.
What I really wanted
And my lord, one more thing.
your grievance is against H1.
Yes.
Have you given a notice to H1?
No, my lord, he's not a party. I am seeking.
He's not a party. Then how can you wanted to have a cancellation of his bid or cancellation of his
No,
matter of.
I'm squarely on a law point, my lord, first.
So without hearing a party who will be prejudiced by an order, you will not implead the party.
My lord, then my lord, I will implead the.
Please implead.
My
What
lord,
are you talking about the law?
One more thing I should apprise your lordship.
But it's a constitutional right. Nobody can be penalized, punished, or condemned without being afforded an opportunity.
Absolutely. We will.
That's a fundamental right. You have to.
Absolutely, my lord. But that apart, my lord, I just want to point out.
Nothing apart.
No, one thing you
First you add.
Yes. No.
Otherwise, I'll say non-joinder of necessary.
No, we will immediately add it. But my
Add
lord,
it.
only one thing, they have filed a counter. State has filed a counter where your lordship's question was remained unanswered. Let them file the affidavit and charge sheet. That's all.
No.
Before this honorable court.
In course of the hearing, it appears.
Get the mining plan, get our EC and everything, my lords. Lastly, they say that they cancelled it on the ground that there is going to be a petroleum, that is Annexure 8. There is going to be a petroleum storage, strategic storage capacity at Chandikhol, my lords, within that area. My lords, when it will come up is an issue, my lords. With this war going on, my lords, petroleum is not coming. They want to build a reserve. And we also have an alternative prayer, my lords, if by chance want an alternative.
We wanted to close the query.
Yes, my lords. On the ground that this SPR is going to come in.
Now can we consider?
My lords, we agree to that. I only pray your lordship may direct the state government. We have given alternate proposals. There are alternate queries. Let them consider it. We have already deposited all the amounts for the mines. Let them consider it. At some other spot where it will not be affected by the SPR.
Yes.
So can you see, yes, under unnecessary, that is the interim order.
Already
There is so cause notice there.
There is a very, you are being contemplating to close it down for a better public.
For national.
We wanted to have the storage capacity now in a today's scenario. which becomes absolutely necessary or inevitable.
Man.
Nobody can deny the necessity of that storage capacity. But what they say is that they have laid for some alternative site to be given to them.
Yes, ma'am.
Can take a decision thereupon. Whether it is feasible, it is not feasible.
That's a separate issue. Let them consider my application. I'll make an
Let
application.
you make an application that will be considered by the government.
Made an application.
We'll make, before the DTM, we'll make.
That is itself in the proceeding itself.
No, but certainly I will make an application.
Yes.
First, they will make an application on the consideration. If you think it is possible, feasible, you do it. If it is not feasible, then whatever the amount you have taken, you have to return with the interest. You can't eat it up. It is your policy decision to abandon.
Yes. That is for national interest.
You have to. But we are directing you to take an decision.
Let you make an application that will be considered by the government. That is also the proposal we have also shared that. That will be considered.
That you have
Yes.
stated.
Yes.
But what have you done? In this
Recently.
No, it is in the month of December.
30
So 4 months.
Yes. That will be sent to the government will take a decision. Let me make an application with regard to that. That will be considered.
Yes, disposal.
God bless.
Item number 21.
Yes.
Item 22.
Item 22, may I please, Your Lordship? Your Lordship, the petitioner is praying for extension of the lease period, Your Lordship, for the term that the petitioner could not operate due to administrative reasons, Your Lordship. The lease agreement was.
For same order, yes. The provision is there.
Yes, Your Lordship, Annexure 3 series.
Yes. Like the judgment 64, you can relax, otherwise this is
Much obliged, Your Lordship.
Item 23.
Demand notice has been levied against the petitioner towards the area TCS of 2020, financial year 2020, 21, 21, 22, and 22, 23, Your Lordship. Now, on last occasion, Lordship was directed to obtain instructions.
If some similar matters are pending here, we have already filed counter affidavit in all those cases. We'll adopt the same counter affidavit, but we'll call on this matter next year.
Lordship,
well,
Up to up.
what are the other matters?
I'm giving you now.
It is submitted.
WPC number 168.
It is submitted for us that the product. For such a long time, you wait for 2 weeks.
Item 24.
Here, my lord, petitioner is challenging the demand issued by mining officer for illegally owning who are stacking the soil, my lord, in the premises of brick frame unit. My lord, may kindly see the impugned demand at page 23. They have imposed royalty, DMF, EMF, and penalty. My lord, I am confining my argument to the penalty only.
Under
51-4. 51-4.
We have already delivered a judgment.
Why that's after if the demand notice, my lords, after
We have delivered a judgment.
this is different in the sense, my lords, that this is with regards to stacking of 600 tons of soil and
The question is only whether there is any power conferred upon you to impose penalty under rule 1. The first question. If there is no power, can you impose? We have already heard that it is only given to a court.
And in the previous round of litigation, they have themselves admitted that they have no power. Mining officer has no power to impose penalty. This is the second round of litigation.
That is what, so far as the other components we are not saying, but so far as the
penalty is concerned.
do this.
I just have one last submission, my lords, that out of 14 lakhs of demand, 12 lakh 16 has been exempted. The remaining is 1 lakh, which is only with regards to the stacking of 600 tons.
Which includes penalty.
Madam, I understand what the facts are, but I am asking you a very legal question. Only thing is you can charge any component except the penalty when the source of power is not there.
I'm saying that I'm sorry.
He has
Saying that we have delivered. I'm sorry, you are not saying.
What are you going to say, Mr. Das? Is this? That penalty under section under rule 51. We have delivered a judgment.
Well,
already delivered.
She says, you are not circulating amongst yourselves.
I'm sorry, my lord.
You have that?
My lord, I don't
In
have.
your case, it is.
My lord, but my lord, may kindly see page 174. Yet they themselves have admitted. And my lord, may kindly turn to page 120. 174. Sorry. Para 7. The previous round of litigation, it is contended by Mr. Such and Such London additional government advocate that rule 51-4 of the Orissa
Same party.
same party. Previously, they have imposed a demand.
But different period.
No, madam, for the same period. Your lordship was pleased to cross check.
How did the authorities defy us? Page 174. You appeared. This transition was on a law point because the earlier we already delivered a judgment.
Para 7.
We simply say whether it falls within the scope of 51(4) to demand the royalty, additional charges, DMF and EMF. But we said that the penalty cannot.
No, even sir, para 7.
They have
That is considered by 51(4) does not empower
mining officer
to impose penalty. Was that wrong observation? Sir?
Then why again in 23 the penalty is imposed? We are calling this mining officer Balasar to appear before us and explain his conduct when this order was already communicated to him.
Taking to my notice just now, let me just discussion with the mining officer. Your lordship may call it next week. Let me call them and have a discussion regarding this.
No, what discussion? He should respect the judgment of the court. He should respect the judgment of the court.
Yes.
And he writes reference number, you see, answer 1.
Yes,
page 23, we come to page.
What about 97? Then what he read? Then how he has read the order?
Lordship in para 8 specifically
They have
directed.
specifically said
Yes.
royalty, additional charges, DMF and EMF. No. Apart from that, penalty we excluded it. And in page 23, he has again imposed the penalty.
And your Lordship have also directed in para 8 of that judgment that the petitioner to furnish all the document and
Mr. Lal,
necessary evidence.
you are a senior advocate.
Yes, but I have understood.
You have to read section paragraph 7 and 8 in conjunction.
Conjunction.
We were simply saying that so far as the penalty portion, there is no source of power. But so far as the royalty additional charges, which is leviable under 51(4), you take a decision.
He has also not assigned any reason, no discussion, nothing. Order. Whatever he says after careful consideration of your reply.
At least we should respect him.
Yes, yes.
On behalf of department, you are submitting.
We are directing him to appeal.
Lordship may grant me one chance. Let me have discussion on the
What discussion?
This order has to go. Prima facie has to go.
He will not understand unless he is brought. Unless he is brought, he will not. Your consultation will not yield any good result.
Did you have any consultation?
Yes, Maharaj, I was sent instructions wherein it was wherein how in the explanation for the royalty has been provided in the instructions.
We understand. You can. Then we have not said so. You can.
It is very clear.
Yes, ma'am.
So he is also confining his argument
Penalty only.
to the penalty only, which you have said that Mr.
Yes,
Das
as per the as per the
on behalf of the department.
Yes, the royalty should not have.
It is allowed.
Litigation options. My lord, in the last occasion, the learned state councils had taken time to take instruction.
And it's here we have received.
Now, has he been discharged from the hospital?
Yes, ma'am, was just recently. Was I received instructions also in the form of para-wise comments disputing some of the facts. So if I may be permitted to file affidavit, I'll file
But
the same
in spite of completing all the formalities and also getting the environmental clearance, they are not allowed us to operate the query launch.
to be paid by the petitioner. There are certain dues which have to be paid by the petitioner after execution of the lease. Therefore, I'll find it be permitted to bring all those
Why?
on record.
They say that there is some dues that.
No, my lord, we have cleared all the dues. We have paid all this money.
Let them say that what are the dues? What is it?
Well, it's
It is submitted by the
Article 3600 matter pertains to RC constitution.
Item number 27. That is important. What you know? Item 28.
Management filed for withdrawal of this petition.
You want to withdraw? Where is that?
Look, number 6154 of 2006.
Where is the bit?
6154.
6154.
This matter is.
Yes, just a minute.
Item number 29.
Petitioner challenges.
Effect of the expedition.
My lord.
What did we incorporate by?
My lord, there has been a subsequent development that the lease period is also over, my lord. Lease period has been over, my lord. It was for the 5 years, my lord.
Has expired.
Expired, my lord. The petitioner wants to amend the prayer for extent of the lease period.
You have only the relief in the form of an extension.
My lord.
Let them, we have already filed a counter affidavit. They can file.
So that also you have filed.
That is
The second proposal.
2 or 3. While the counter to the amendment application to be allowed, will dispose of the main matter.
And that's what to copy and serve.
Oh.
I have served the copy, my lord, and I'll serve another copy.
What is the submit the copy of the amendment?
Item number 30.
Yes, there was. I think 30 minutes passed already. About the tax matter?
Yes, please. Yes, ma'am. Madam, in this case, the RC has been cancelled due to place of
What adjournment you are asking?
no, but this is not like non-filer cancellation. This is place of business cancellation. We have already filed counter.
I'm asking for an adjustment, sorry, no, it should be
23rd.
23rd. Okay.
Item 31.
The pronouncement of order, Your Lordship, hearing on
Give us more time because we are more busy for some things. So the on 21st.
will be pleased to keep any time.
Item 32.
This is the review application. And I guess official lordship. I commence my argument before lordship by referring to your lordship's judgment, which is reported in Orissa Lift Litigation Corporation case. If I may just restart by placing the same judgment, relevant paragraph, lordship. Lordship has this list of citations which I submitted on the last occasion. Okay, flag C. I'm placing paragraph 5.5 at page 4 of that citation. Where errors yes, let's continue. Where an error is not self-evident, it's serious to be an apparent error. Once a mistake on the face of the record is established, what order should follow to correct that mistake shall always depend on the facts and circumstances declined to rectify the mistake. If the mistake is one which requires determination of some undecided issues, because it has not been decided, though raised, the procedure that should follow would follow the discovery of such mistakes is to recall the order and decide the case afresh, or to decide that issue after affording an opportunity of hearing to parties concerned and pass a fresh order in light of the findings of the investigation. That apart, certain relevant paragraphs like Lordship relied upon the city infra project scales, wherein the Honorable Supreme Court had recalled the order and we had to back it. And with regard to a particular paragraph, where Your Lordship has indicated that where there's substantial and compelling nature, Lordship will interfere and recall the order. My submission to remove this law. Let us say that something which was argued and has not been taken note of by the judge. Then in article it is open to the court to correct its mistake and decide that point itself by recalling an order or by replacing the judgment of this. Now the first issue is whether the same was really argued or was not argued. Because in a judicial parlance, there may be multiple points which are taken in the minutes, but at the time of an argument, the restrictions is made to a particular problem. So in that event, I think these being the factual aspect, they have to corroborate whether it was argued or it was not argued. Yeah, you see. Then it's a form of an affidavit because they have said on affidavit it was argued and they did not taken. Would you like to deal with that aspect?
So we have filed a counter affidavit. We have already filed a counter affidavit.
What is the stand taken by?
But our stand is that the submissions already made. The court accepted the submissions which were relevant. It is not that I can argue maybe 20 points, 30 points or 50 points. But it depends upon the court to accept and deliver the judgment. Suppose court thought it proper to address on certain specific issues. Court did not thought it proper to delve into those issues. But can that be re-educated and reopened by a long-run process of reasoning in a review application?
Then should I take it that you have said that yes, that was argued?
But my learned friend wants re-hearing of the...
No, that is a different issue. Why he is taking something different. He is taking a different route.
Review. Certain fresh documents. Is never from part of legal. In more comfortable, bring on record certain documents which were never before the report.
We have only referred to the guidelines only. The guidelines.
You, sir, my lord is asking you. He might have taken that stand, but he has not enclosed. That means he has not argued. Then can he? And you are supporting his yes.
But he cannot.
Sir.
Something which is already argued, or if not argued, can it be reopened in a review petition?
I am asking, sir, he's taking a particular observations as a guiding lines for his review. He says that if something is argued, if court did not take note of that argument, I think that in which it is open to the court to recall its order, rehear the matter, decide of the matter. Or the second option, which the court will give an opportunity to rehear and then can deliver a judgment, taking into account that aspect. So first is factually, the factual aspect, that whether this point was argued or not argued, you have to be very specific. If you come not argued, then the question of oath versus oath. If you say argued, then we have to take it that this was not decided. Then we'll have to go into this whether it is decided, any reference, any kind of a consideration is made to that or to those arguments. Then the second aspect will be open whether those arguments have some kind of a substance which would tilt the judgment to diametrically opposite. The second aspect, the fringe, as you say, the fringe issues cannot be reopened, but it has a material bearing, then
College on 21st.
You are not drafted. This counter you are not drafted.
Mr. Das, know the law.
You are not consulted him. You are not consulted. Auditor called out from the charge.
You add certain notifications, the guidelines. How can you add lower counter to the review petition?
It's not unique to associate lordship, and the officer of the court, my lords. This annexure which they have annexed is annexure A by 1. That what record by this affidavit. My duty as the officer of the court, my lord. Fair enough. They had annexed it in the contract in the data connection.
Wherein the connection A and B.
Yes, B is there in the read petition. I have annexed it. Or you will find it at
The same thing.
yes.
D by 1. D by 1.
B by 1.
D by 1. Notification dated 22/2021.
Yes, this is part of my data application record. So
Guidelines for hospitals devices.
this is the annexure to my data application.
Annexure
3.
3, but here you show, please, read. Just read this annexure A and B for the same. Sir, A and B, very.
A1 and B will look.
Please calculate count of
Yes, 28 B by 1. That is only
2021.
yes.
So this menu includes as annexure A and B. The government have approved the detailed guidelines for the analysis of revenue schedules as annexure A and B.
Yes, I have the, because I had also filed the same guideline, annexure 3 series, has given the relevant pages which are relevant for the case. I have the entire set of the guidelines with me by way of a memo. I had claimed liberty in the rate application in case a lot of wanted the entire. Yes, Madam in read petition, I had kept it on record in case during the course of hearing your lordship wanted that entire guideline.
I do not approve this particular, the notion or the concept of relying on a document issue memo, which unless it forms the part of the hearing, one has to stand the testimony through the veracity, authenticity, and the genuinity of the document by virtue of the pleadings. As memo, suppose if it is a fabricated document, then it does not forms part of the affidavit. So what the court will do, they accept that document. So they accept the document. I do not know. That is what is the main problem here. That's what they have done is, this is a guideline by the state government.
When court accepts your document.
And it's on affidavit.
So judgment is erroneous. Even we have not taken.
No, I'm not.
Note of your documents which is filed removed.
Well, that is part of the documentation of the writ application. Lordship kindly appreciate. My reference was to this guideline in the context of the fact that this guideline is binding on the opposite party of one. Now, with regard to
Make us clear on pleadings.
now, this guideline has any statutory sanction. It is I'm asking, or it is merely an executive document. With the Lordship's permission, since this aspect of was not gone into my submission at this stage, whether the guidelines has any statutory recognition. My lords, or it is an executive instruction. Yes, ma'am. My submission to my lordship it's formulated under Article 162. Where is the sanction of the governor? If the lordship has a rule, there is the guidelines shows. Where is the guidelines which talks about guidelines is like 162 minus. Say executive order. Is it? Lordship has review or referring what? It's in the writ application manual. Where is the Renextion 3 series? Page 61 of the writ application. At the top, it's referred as notification. 5056 was the previous notification, supersession of the yes. And if the lordship has a look at the rules of service, the rules of business, I have an extra copy of the rules of business. 162. I flag mark the relevant department's authority to obvious. What it says. What it says. Well, this is the guideline for the entire state of Orissa. Wherever the government health institutions are floating requests for proposals, all the fresh proposals wherever floated has to be in consonance with this guideline. I am asking you, what is the departure from this guideline? Must I'll come to that. If the lordship to know. Yes. You should lordship to see that what will the significant departure. Yes, ma'am. The lordship comes to page 61. It starts there. Thereafter the lordship series.
61 of the writ.
Yes. In supersession of the department. Where they have gone wrong and has defied the guidelines. Yes, that is my duty. Yes, show me the relevant portion. Yes, I'll first show you the lordship, the relevant pages. The lordship comes to page 67. Yes.
This is the format with regard to the eligibility criteria. Lordship sees clause 1, I'm sorry, clause Roman 5 under 2.2.
No, what is the guideline? Where is the guideline?
My lords, this is the guideline under which.
No, this is the request for proposal, sir.
Your Lordship, kindly appreciate, they have floated a format. They have given a format for all government institutions to follow this. If Your Lordship has the entire thing, this is a format under which. This is a format under which all government institutions.
Just 1 minute, I do not find.
Sir,
Page 63. Page 63.
I am reading from 61. In supersession to this department of education, numbers 24.
Yes.
After careful consideration, government have approved the detailed guidelines for the enhanced revenue enclosed as Annexure A and B. Then turnover 63. Comes to page 63.
Yes.
That is request for proposal.
Yes.
So where is that Annexure A? Where is that Annexure B?
Sir, give me the authenticated copy of it. This cannot go in this way.
They might have tried by Mr. Lordship has the entire guideline.
Where is the guideline? Let me see. What is the guideline? That's the rule of business.
No, stand fine.
The handwritten revised. Handwritten. Where is the original publication, Mr. Das? Mr. Das. What is the original? Can you produce? Is it the correct that this request for proposal is Annexure A? Well, that's a very unique way of. That's why I am.
In fact, that is my submission to the Lordship.
It's a very unique way of guidelines. The guidelines are not issued in this form.
What happened is, in fact, I'll just apprise the Lordship's background.
Sir,
What happened?
Sir,
My lords.
come to page 63 of the writ petition.
My lords.
This Annexure A revised is not written.
That is what I say. Who has
That you have filed an affidavit. But in the memo, you have written in handwritten. This Annexure A revised. Bracket.
That's create a confusion in our mind. 63 does not contain Annexure A, but in the memo you have given, it contains Annexure A handwritten, revised. What is the correct?
I don't have that. You don't have to. Very much.
Go. So if disparity is noticed, that's the original annexure. And this is the additional memo, but that is conspicuously annexure A.
That it's a department thing.
I do not know this is what is there, so that creates a confusion. So which one is correct?
The writ petition, you have filed an affidavit.
My humble submission is what must have happened.
Sir, Sir, writ petition, you have filed an affidavit. It is conspicuously absent this part. And by virtue of memo, you have inserted this.
No.
Sir, what to?
My humble submission.
Mr. Das,
Hence
can you
after we
produce
will,
the original?
hence after we will not.
Let him produce. No, not necessarily. What he has downloaded, we have done it.
What have,
So let them produce the
let me
original.
clarify what must have happened is, why at the time of filing, so that it doesn't create a confusion, why probably he has mistakenly used ink over that particular.
No, it's not that, because we have to look at the document, whether it is in.
This is the original manuscript, which I got from the authority.
The point is taken by the petitioner that
What I understand, what we must have done with findings, that since that may create a confusion. This was not.
we are not being serious about it. But let the witness produce with the original and it conveys, because my experience both side is whenever the guidelines are issued, it is issued in a different form. It is issued in a narrative form, not issued in this form.
Actually, guidelines are not law finished.
I am for lordship with the document there.
The restriction also, there is no annexure B.
No, what?
You relied on annexure A.
I'll just give lordship, give me 1 minute, I'll just write. I am actually comparing these guidelines and relevant provisions which are not being complied with in the original tender, which is under Annexure 2. So what I did was, I took out the relevant pages of the guideline, I kept the entire thing on memo, so that at the time of hearing, if your lordship was during the writ petition, I could file the entire thing. Now, what has happened is, while filing, what he must have got confused is, since Annexure A is written above, he may have thought that this is confusing the court. Let me put a white on that. That may have slipped. That's a slip. Document is original, but as provided in the yes.
Item 33.
Out of 5 matters, first noted was reading case. In this case, your lordship almost in all the identical grounds it is reflected, all these portions. But unfortunately, in other 4 matters connected here, no order has been passed. The fourth one is ready.
Is it correct that we have already earlier decided some matter?
Interim order? No, in this case, interim order is passed in my favor. In connected, some power matter is there also. You also, it is with regard to bid capacity. That bid capacity in the tender, litigation process shows that how bid capacity has to be calculated. The arithmetical formula is there.
There was one matter which we decided.
Mr. Rathore was arguing that.
Yes,
Successful bidder was acted as party and notice had gone to him before. He has already entered appearance, yes.
No, there, I think, on the last occasion, something, if I correctly remember, the last you are appearing. In other matter, the senior advocate, Mr. Rotto, he was saying that calculation A into N into something, that is what the formula.
Yes. The formula is there. A into B into
Whatever.
Yeah, A into N into 2 minus B.
That is the E and I remember. That
A and B.
Minus something.
Minus B.
This Das was there.
All these,
This is Das, Aishwarya Das. She was there.
I think we concluded. Have we decided some? I believe that we have dictated.
yes, your lordship, but I heard that, I don't.
I have
really
dictated.
remember that particular
I
number.
believe that we have. No, there are
I remember, my lord, you have to dictate.
I think, yes, dictated. That is what I remember. That is what I'm saying. And put something as formula was. We called the officer to explain, if I correctly remember, the officer came and explained that how this formula works, if I correctly remember. Huh?
In that case, order is not dictated.
Not dictated. Sure.
Yes.
Ask Mr. Rock whether it has been dictated. Because he was pointing out. So I'm keeping this matter on 21st. Just see if it is not dictated, then that matters we also tag with it and we dispose of the matter on
21st in supplementary.
Supplementary. We dispose of all those matters.
Interim order is not there in the connected.
No, the order is there in Mr.
First case.
If I correctly remember.
In my case also there is an interim order. In my first lead case, the sub item 1.
Take care that if it is an interim order, don't. In those matters, it is governing the same thing. Government law.
Because that law already.
Bit advocate is here.
Our own matter log.
What was this?
That is 33, my lord. Welcome to fast working.
What is the matter?
Yes, I'm in sub-item number 2. It is Salu.
Lord, I am appearing item number 1, RP Saw. Ramesh Prasad Saw, my Lord.
Yeah, no. Yes, on the hearing.
Lord, there is
There are several sub-items. There is one sub-item of Mr. P.K. Ahluwalia, is one of the lessons.
Not KJ
I'm sorry, KJ Ahluwalia is one of the lessons. Now, his lease was auctioned in 2020. And because I appeared for. What is the charm in the name? Because there are two brothers.
No, sir.
There are two.
They will not be considered. My friend, in fact, appearing the intervener.
So I not intervener. They have made them pro forma part.
Pro forma part.
So, Lord, I am.
Let me.
Just give me half a minute. Lord, I am GSW. I took over this mines on auction. Now, it is their case, my lord, that the material has to be lifted. Now, my difficulty, my lord, is I am pro forma opinion number 7. I am the lessee who came by way of auction. So I was the successful bidder for this lease.
It is only done.
And more than 10% of the area is held up by their stock. All that I am saying is, please remove the stock. Whoever wants to take it, whether the state wants to take it, they want to take it. Allow me to mine over my almost 84 hectares of land. That's my short of the state.
The past matter, in the past matter, I have also. In the past matter, I am.
You were only in 175? Yes. Only one man. What other matter? No. Because I am the successful bidder. I am the successful bidder. There are another reason for that. Yes.
In the past matter, I am appearing for the pro forma opposite. There also I have filed an IF for same prayer.
Issues are common, my lord. Issues are common. All orders are on similar terms.
What about the main matter?
Second one.
Main matter is non-consideration of the representation before the government before the expiry of the lease term, lease period under 12 FL, permitting on the situation of force majeure 7 months time to remove the stock that is already raised. So that was rejected by the state government. First, the reason is saying that there is no force majeure. The period was from March 23, 2020. The force majeure was there because of the COVID pandemic. And the situation, the second part, my lord, prior to the expiry of the lease period, the petition. You are appearing in what patterns? Sub-item 2. That is KJ Ahluwalia.
Lord, item number 1.
Who is appearing in what?
Lord, I am appearing in Ramesh Prasad Sao, my lord. I am through VC.
Yes.
In Ramesh Prasad Sao.
Consider this argument. In what matter?
Lord, this is read number 17796. That is item number 1 in the batch, my lord.
Yes. What is the
last time, my lord?
What is the point?
Point is, my lord, that my lease expired in March 2020. As per a statute, the state government granted me 6 months time. That ended in September 2020. Before end of time, I filed a representation before the state government because of severe COVID lockdowns and consequent restrictions. I could not utilize that 6 month time fully. So I could not remove entire material, though I have removed substantial material. So I represented and I asked that there should be extension of the time. That was rejected by cryptic order without consideration. And mechanically they passed one line order that we are invoking 2L1HH. We filed writ petition and that writ petition was disposed of by order dated 22nd December 2020. That is annexure 3 in my writ petition, my lord.
Yes.
Last time I was referring to paragraphs of this writ petition, my lord. The court set aside the orders of the state government and court said that the secretary will hear the matter and he will decide in the light of discussion made in the judgment and on case to case basis. But what the secretary has done in this case, my lord, that he has decided separate cases, but again cyclo-styled orders. He has not considered any of our submissions, and he has made some generalized statements, and he has created some statistics data which were never shared to us, and he relied and he passed order on the basis of those data, my lord. So may I show the order of this court again to refresh, my lord, though I referred some portions last day, my lord. May I show?
Yes.
At judgment annexure 3 starts from page 171. And in the on page 171, my name is given, my lord, in previous round, item third read petition, that was 27731 of 2020, Ramesh Prasad Sahu. So all these batch was there, my lord. And my lord, discussion, the operative portion starts from para 46. Am I para 46, page 241? May I? Para 46, page 241.
Yes.
Internal page 21. We have given our annexous consideration to the rival submission, carefully peruse the material. 241, my lord. In my paper.
From where you are reading?
I am reading at 241.
241 is not matching.
Internal
Which petition?
Internal page 71.
Oh, so 17796.
Yes, my lord.
You have given me a wrong.
This is first item.
Give me. No.
In my paper book, my lord, it is annexure 3, starts from page 171. I am referring to page 241, where the operative portion of the judgment is there, my lord.
Yes.
This is first round, my lord.
Yes.
So,
what it says on consideration?
This, after discussing all the contention, ground situation, COVID effect, court said that authorities should not have rejected their representation, because force majeure itself is a condition in the lease as well as a provision in the statute. So authorities should have considered it, applied it, and then decide not by passing one line order or stereotype order. So may I show some discussions below, because these discussions were to be applied by the authority. So I am referring from para 46 below, finding starts. I will skip para 47 little bit. Some portion of para 47 below at page 242, there is discussion with regard to my mind. That is likewise in writ petition number so and so filed by Ramesh Prasad Sahu. Also, petitioner has challenged the order dated 1/10/2020 and rejection of representation by the annexure 3 and 9/10/2020 by raising same ground. My lord, just skip that para, and there is sub para on the same page from factual narration. This is the I am emphasizing, my lord. From factual narration indicator here in above, this court finds that common thread running through all these cases that their lease stood expire on 3/1/2020. All the parties have been served with notice dated 1/10/2020 upon invocation of power under 12(1)HH of the rule. In 3 out of 8 petitions, there have come new lessees, whereas in 2 of them, ex-lessee have again become new lessee. In one case, it is observed that 9 of the leaseholder is non-performing mine. There is also a case where leaseholder area was put further lease. But surprisingly, in all these cases, competent authority of the state government has passed stereotype identical orders to the effect that time granted to the petitioner under provision 12(1)GG for removal of excavated mineral, plant and machinery, etc., commenced from 30 March 2020, and thereafter notice under 12(1)GG was 12(1) HH was served on 1/10/2020, granting them 1 month, which came to an end on 31 October 2020. All the writ petitioners have approached this court with common plea that they faced enormous difficulty in their affairs involving transportation of raised minerals, plant and machinery, etc. In some cases, only mineral. One of the cases involved only transportation of plant and machinery. Common argument has been advanced by the learned senior advocates appearing in all writ petitions that towards the end of March 2020, the country in the wake of COVID-19 pandemic faced unprecedented situation leading to 6 phases of lockdown intended to avoid spread of coronavirus. In first stage, implementation of full curfew, while in some part of the country there was a weekend curfew, and later in some other part of the country witnessed night curfew, which process continued with some modification or other up to a stage 6 lockdown. Then the country introduced unlock 1 and onwards, which is still continues. Then para 48 is again I'm emphasizing, my lord, all learned senior counsel appearing for the petitioners were unanimous in the submission that situation in country as a whole was so chaotic that everybody was under trauma. It is in reference to different notifications introduced at national level as well as state level that almost all advocates submitted that though there was no restriction on paper, this is important, my lord, because again, Secretary has says there is no hindrance. So though there was no restriction on paper, insofar as mining activities or transportation of mineral are concerned, but on the ground situation was totally different. Looking to the nature of direction issued at both levels from time to time, there has been tremendous fear amongst citizens of the country, bringing to the notice of the court some of the circulars. It has been argued that in view of variety of restrictions, there has been different type of dislocations. Instances have been cited showing shortage of manpower. This is important. Shortage of manpower, rampant migration of the laborers, closure of eateries on roadside and national highways as well as the state highways for indefinite period, making it horrible for the drivers and other persons engaged on trucks and transporting such minerals, thus causing immense difficulty, thereby resulting reduction in the availability of the trucks, manpower, storage of movement of citizens due to lack of means of transportation, several other restrictions, almost bringing the entire nation to grinding halt, at least for first 3 months. As the time passed, some district administration imposed day curfew, some imposed night curfew, some imposed week curfew, some imposed weekend curfew. It is also commonly urged that a state administration introduced capping on this is very important law. The state administration introduced capping on movement of trucks to different destinations, creating uncertainty involving transportation to other areas. All in the market position in the whole world created deterioration in the financial of every individual. It is urged that this all resulted due to COVID-19 pandemic. Therefore, a state government cannot be allowed to contend that there was no effect whatsoever on the ex-lessee. So this was contention of the state government in first round, my lord, that there was no effect at all on the lessee. That again, it has been noted here, my lord. In this situation, when National Disaster Management Authority declared this pandemic to be natural calamity and central government taking into consideration situation issued various notifications and circulars providing relaxation to different type of business activity, financial incentives, introducing relaxation in variety of the areas, suffering due to pandemic situation in the country from March to October 2020, including one issued by the Ministry of Mines. This court is inclined to hold, kindly note this line, this court is inclined to hold that the state government was under a statutory obligation to examine the grievance of the petitioner whether or not they have made out a case for invoking force majeure clause under 12(1) FF of the rules 2016. This court is inclined to uphold the argument of the representation of the petitioner could not have been rejected as not maintainable because force majeure clause is very much included in the lease deed as one of the condition, and it is also available in rule 12(1) FF. So this is finding of the court, my lord, that you can't say that the consideration need not be there. And my lord, the competent authority of the state government ought to have therefore examined such application representation of the petitioner on the basis of whatever material they relied in support of their claim on case-to-case basis and decided them by speaking and reasoned order rather than hushing them up by
No,
describing.
I understand. Ultimately, the court, while disposing of your writ petition,
Yes.
set aside the order rejecting the same and directed that since you are trying to invoke the force majeure clause,
yes,
and then the matter was remitted to the authorities to take into consideration in the light of the observations made
yes. That is there in para 77.
therein, and to consider the same. And you were also given a liberty to place all such materials which are there in your possession.
Yes, my lord.
Before the authority.
Yes,
now, what the authority did?
Yes, that I am coming. My lord, para 77, whatever my lord is saying is there in para 77.
No, I have already. That's why I'm asking. I read
one
paragraph
line-
77.
Yes, one line I want to emphasize, my lord. The authority was to decide on case-to-case basis on the basis of my material, my lord.
Yes.
What authority did in this case, my lord? Authority copied my representation, copied my written submission.
Where is that? Where is the replica of the earlier?
Yes.
That shows a non-application of mine.
Yes, my lord.
Where is that?
Is impugn order, my lord. That is annexure 1 to the writ petition.
Page?
That starts from 116, my lord. 116 is covering letter. Order starts from 117, page 117. Annexure 1. This is order dated.
Yes.
Now, my lord, may I show the structure of this order, my lord? In first para, he is referring my facts. That is not in dispute.
The second paragraph is the operative portion of the judgment.
Yes. And this main contention by the petitioner.
And then the third paragraph is the representation.
Yes, representation copied as it is. That is copied as it is, my lord.
Till?
And this goes up to after copying that, this goes up to page number 160, my lord. 160.
Yes.
Let me show a little more detailed findings of this authority, my lord. That findings comes at 152. I'm sorry, my lord. Page 152. After copying that, authority says on analysis of the facts and contention of the petitioner.
Yes, just 1 minute.
Page 152. Two is the finding, my lord. On the analysis of the facts mentioned, the petitioner Lease along with facts on government record, the findings are as follows. I am saying, my lord, these findings again perverse, my lord. With all due respect to the authority, I'll show how. Para 38, my lord. There are 24 mining lease holders. This is first finding. There are 24 mining mines, including the one belong to the petitioner, whose validity expired on 31 March 2020 in accordance with provision contained in the law. All 24 lessee, including petitioner, were covered under 12(1) GG 11 HH of the MCR by virtue of the respective lease deed. validity of which expired on 31/3/2020. All these 24 mining lessee holders knew very well, almost 2 years in advance, if not more, that their lease would expire on 31 March 2020. Milord, what he has failed here, Milord, I could not visualize that.
I understood what you want to say. Anyhow.
He did not say that. I did not realize that COVID will come in March, Milord. Of course, I visualized. So I'll explain that. All 24 will hold a new value that, if not for that, the state government visualizing that petitioners might not be in position to transport the whole mineral stack on the leasehold area on consideration of representation at instance of their association, issued notification dated 4 October 19 and provided each of them the scope of intermediate storage with a future conditional additional period of 2 years up to 31/3/2020.
Yes, sorry.
Yes, may I continue, Lord? So what he is saying that I should have visualized that my lease will expire. Of course, I should have visualized that. But what I could not visualize that COVID will come, lockdown will come right at the beginning of my period of 6 months.
Now, why you say replica, sir? Why say it is a copy and paste or cut and paste?
Lord, this portion, I'm sure, Lord, in all cases is recorded like exactly in
No, that is a different issue. I'm just asking you because in an earlier occasion, has he taken into all these aspects?
No, earlier was one line order, Lord, mechanical order.
So that is a fresh exercise. The reasons may be perverse, the reasons may be cryptic, the reasons may be, does not stand. That's a different issue.
Yes,
that's a different issue.
Let me make my submission clear, Milord. What I said that he has copied my representation, copied my argument up to page 152, and thereafter he has given reasons which is not related to my argument, Milord. He has created some statistics, and that statistics form annexure 1, 2, 3, 4, 5 of the impugn order. That annexure was never shown to me. On the basis of that annexure, he has
You just show me the relevant portion from the impugned judgment.
Yes.
That the authorities have taken care or taken into account the force majeure clause, which was the direction passed in an earlier round of litigation.
Yes, that's why I'm saying.
Has he taken or has he considered or not considered?
No, he has said that during COVID there was a better situation in respect of the transportation.
Where is the findings that he says?
Yes, sir. This sub-para of this para only will say, Lord. Let me show that, Lord. Para 152.
Para 40.
Para 40, Lord.
Yes.
Let me show them, Lord. This here he has said that a state government has provided alternate storage, Lord. This is not completely given in a correct way, Lord. The state did not provide a storage. The state only amended OMPTS rules. I'll show that notification, Lord. That I have annexed. That notification is at annexure 12. My Lord may note here. He has said that the state government visualized this situation and granted them alternate storage. There is no grant of alternate storage. There was enabling amendment in the rules. Lord, next para 39. Lord. This is the finding, Lord. So let me show this finding and then I'll make my argument. Lord. Para 39. All 24 mining leaseholders were well aware of the fact that I'm reading para 39, Lord, would come to an end on so and so. The state government visualizing that petitioner might not be in a position to transport mineral so and so. So he is again talking of storage. On storage, when I make my submission, that for making a storage, I need forest clearance, environment clearance, which is a time-taking job. It can't be done in 6 months or 1 year. He is saying it is your responsibility. He is not dealing that how it is relevant or not. I will skip para 39, Lord. Now I am para 40, Lord. Let me show para 40. That even when this is the most crucial line, Lord. Even when lockdown was imposed, it needs to be stated here that the state government had consciously taken decision to permit mining operations, all activities related to it. As such, there is no prohibition in the mining operation or transportation of mineral imposed by at any time during lockdown period as evident from circular so and so. The state government. For these reasons, the state government did not make any distinction between movement of essential, non-essential goods. There was no prohibition in mining operation or transportation of mineral imposed at any time during 95% period of the lockdown, as is evident from circular so and so. Beloved, same argument was made there that there is no prohibition or restriction on paper. So he is making that argument again. I have shown in the High Court order, my lord, when court noted that of course there is no restriction on paper, but ground situation is different. Now then 41, my lord. And this 41 will show, my lord, again that how is made this finding, my lord. It is worthwhile to note that some statistics, and these statistics has been created after hearing the matter in his office, my lord. It is not known to us until this order is served upon us. So it is worthwhile to note the some statistics which were very much relevant to establish whether and to what extent dispatches of ore adversely affected due to conditions emanating from various restrictions imposed on account of COVID lockdown. Total dispatch of iron ore from all above 24 mines has been to the tune of 23.53 million ton post expiry as per tabular statement included Annexure 1. I'll come to Annexure 1, my lord, in a while. Taking data of total dispatch of iron ore from all above mines, leasehold area expired, the total dispatch has been to the tune of 23.53 tons after expiry of the leases and within the permitted timeline as per tabular statement of Annexure 1. That said tabular statement further indicates, and this is finding, my lord, that cumulative dispatch from all 24 mines has been maintained at 2.5 to 3 million tons per month from April 20 to October 20. This is indicative of the fact that dispatches were going on unhindered by similarly placed leaseholders, lessees located in very same geographical area indicated if dispatches were adversely affected owing to various restrictions imposed on COVID-19 lockdown, it would not have been possible for other similarly, this kindly mark this language, other similarly placed lessee to dispatch their mineral at such level. Lord, it's not other similarly lessee. I am the second highest in that batch. Let me straight away show the Annexure 1, my lord. And that picture will be clear. What he is inferring from Annexure 1 is not coming from the reading of the Annexure 1. May I show the Annexure? May I show the Annexure 1, my lord, at this moment to deal with this argument, my lord? Annexure 1 starts, my lord, at the end of this impugn order. This is Annexure 1 of the impugn order, my lord. It is on page 161. My lord is there? May I show Annexure 1?
Yes.
Yes, my lord. This is 24 leaseholders as per the state government whose lease has expired on March 2020, my lord. My lord may see my name appears at serial number 11, RP Sav. And see, my lord, what was the opening stock on 1 April 2020? That was 102, fifth column, my lord.
No. 63, 55, 363.
55, 363. Yes, I'm sorry. This was the opening stock, my lord. And at the end of that 6 month period, I have dispatched almost half, and now what is remaining? Total dispatch is showing, my lord, 28. Second last column, my lord, 28,30,209. My lord, find that.
Yes.
Total dispatch is 28,30,209 out of 63. And if my lord compare others in this table, there is only one lessee. There is only one lessee, that is Rungta, who has serial 14, who has transported more than me. So in in finding, he is saying कि other similar lessee have transported, you have not transported, so you can't claim COVID. But here in the annexure, I am the second highest, second best below. And on first best, that is Rungta at serial number 14, I had a very crucial difference. Rungta had no reliance on the road network, because Rungta has a dedicated railway siding in its leasehold area. So many transported related restrictions were not applicable to Rungta because that was applicable only on road. This is one point. The second point, in counter estate has said you also have access to railway sidings. That railway siding which is nearest to me, I have given in my rejoinder lot, is 20 to 30, 25 kilometers away from my leasehold area. So I can't be compared with Rungta, but in comparison to all others, all other 22 lessees, I am the best below. Those who are transporting the through road. So the conclusion in annexure that similarly placed lessees are doing and you are not doing is not factually correct, my lord. If my lord see the second last column where my lord find the total dispatch, somebody has dispatched 4 lakhs like serial number 1. Somebody has dispatched only 88 lakhs. Somebody has dispatched only 828. So how he can be compared, my lord? My lease was big lease. I had 350 hectare lease. Somebody has only 4 hectare lease. How can he be compared, my lord? So this is totally irrelevant comparison, my lord. And that's why I said, my lord, ki the order per se is leading to perversity, my lord. Suppose, my lord, in some cases there are only 126. Some cases is only 4,000. Some cases only 189 metric ton. So they can transport in one day. And they are being compared with me saying that they are similarly placed lessee and they have done, you have not done. Am I clear in my submissions, Lord? So on annexure 1, this is my first submission, that I am one of the best performing. On annexure 1, I have second submission, my lord. If my lord see the volume of transportation from April, May, June, April it was minimal because lockdown was implemented with full force. May, June, it remained very low. And then after July, when unlock was started, then the situation gradually improved. And that fact, my lord, will find from total grand dispatch. Last row, my lord, on annexure 1, grand dispatch, for example, in April, there was total transportation of 17,60,000. May, it was 27 lakhs. In June, it was 35 lakhs 65. July, it is 41 lakhs. So it is improving as the situation is getting relaxed. It is improving, and that is my case. That initially it was complete restriction lockdown. Later, and it was unlock phase. Then it improved and it improved, and then, my lord, in this situation, I could not achieve 100% transportation of my stock. That is my. Then, my lord, may I take my lord back to the impugn order again? Serial 16. I'm sorry, my lord. On annexure 1, my lord, may note there is serial number 16 also. The highest serial 16. Serial 16 Rungta Sons is the highest. And they have railway siding in the leasehold area, so their case is entirely different. They can't be compared with others, my lord. May I come back to the impugn order, my lord? I was on para 41. Now I'll read para 42, my lord. and then again I'll go back to annexure if required. Otherwise, I have shown that annexure. That as mine-wise comparison of, I'm reading para 42 at page 154 bottom. That, may I proceed, my lord?
Yes.
Para 42, that the mine-wise comparison of dispatch figures in the said tabular statement, that is annexure 1, indicates that 19 lessees, this is very absurd, my lord, 19 lessees have planned the monthly dispatch so as to able to evacuate 90% of total stock lying on 31/3/2020. Further, monthly dispatch from mine has been maintained at the level 0.75 million ton, indicating that there has been no bottlenecks for transportation of minerals during period of question. So nobody is saying it's a total non-starter. We have tried our best and we have achieved significant quantity. Only thing that if there was no restriction, I could have done entire. So that's my point. As simple look at Annexure X enclosed with this order would make it clear that while lessee like Rungta Limited, Aryan Mining were dispatching in the range of 4 to 7 lakhs metric ton per month on average, the present applicant has dispatched only in the range of 1 to 1.5 lakh metric ton per month during April to June and picked up dispatch only from July. These points to the lack of seriousness on the part of the petitioner in taking up the dispatches in right earnest in compliance to the rules. Main edifice of the argument of the petitioner is based on ground invoking 12(1) FF. It needs to be appreciated that any force majeure event impacts geographically contiguous area and not isolated in its impact to one particular lessee. My lord, may I proceed?
Yes.
Yes. He is saying that main edifice of the argument is 12(1) FF, and he is saying that the force majeure will impact everyone equally. And then he's saying the COVID-19 pandemic is a global phenomenon and must affect all lessee in present context. The available data shows that while other similarly placed lessee in the same neighboring districts were able to dispatch their minerals on regular basis in huge quantities during these very months, it is not understood why the petitioner was unable to do so. My lord, I have shown the annexure. I am the second highest and the first highest person is having railway siding. So he can't say that I am worse off. Then the argument forwarded by the petitioner implies that adverse impact of force majeure impacted his operations and dispatches while sparing other similarly placed lessees. Such argument is devoid of any logic, as force majeure event cannot pick and choose entities. It's not my case, my lord. Somebody is 10,000 with me. This
What is that?
Disconnect. That's right.
No, there was a disruption.
I'm sorry, my lord. What I was reading, my lord, para 42. In para 42, he is making argument. There was 24 leaseholders.
No, that you have said.
Yes.
That these are the list of the 24 the mine holders, leaseholders.
Yes.
See the performance, what they have done. Your performance was on the second position. You have done it. Rungta is one. But the advantage of the Rungta is that he has the railway connectivity for dispatch.
Dedicated railway siding in the leasehold area. Dedicated railway siding in the leasehold area.
That is what you say. That's the personal railway siding is there.
Yes.
So he could mine through railways and he can also mine through roads. So major portion may have gone through railways. So do not go by the figure.
Yes. That's why I'm saying, Milord, the comparison is inappropriate, and one side he is comparing with Rungta and other side
So his major thrust is that when there was no absolute restriction which was created during the COVID-19 time. The peoples were free to the dispatch those iron ores. Then why you want to take an advantage of those force majeure clause?
Yes. So that's why
That is what is the total, I'd say, summum bonum of the entire,
yes, my
you
lord.
know, the reasons or the findings.
Yes, that is
And
why.
the comparison they wanted to make, according to you, there cannot be any comparison with the others because your performance is always good.
Yes.
The bottom line of the story is that why within the statutory period, you could not remove all the articles.
So that's why, my lord, I was showing when I was showing Annexure 2, I made second argument that the Annexure 1 is also showing that overall the transportation was lower in at least first 3-4 months, and once there was a improvement on ground, the activity picked up. So that shows that the annexure itself shows that of course there was an impact of COVID on the ground. That was second argument. Here he is saying that when other 19 similarly placed leaseholders could transport their mineral in that 6 months, why you could not do? So on that I have said that where perusal of that second last column of Annexure 1 shows that my quantity was far higher than the others. Some person was only transporting 10,000 metric tons. Some was transporting only 5 lakh ton. My lease was bigger. My EC was bigger. My dump was bigger. So this method of comparison itself is wrong. That is what I'm saying. And what he should have decided, he should
What
have.
is the present scenario? Is it occupied by a new lessee and he's mining there? And
Yes, OMC has taken this lease under 1782 Milot by reservation, and OMC is mining there. In fact, OMC moved an application that this should be removed. I also said in court that this should be removed, and we are only seeking very limited time that kindly allow us to remove this mineral. It is nobody case that it is not my mineral. It is nobody.
It is still stacked at the site.
Yes, my lord, it is there at the site. We want to remove that. We want to vacate the area. In fact, I have given all my plant machinery infrastructure to OMC. As a,
you have given this gratuitously.
Yes.
Oh.
Because I knew that for transporting this material, I will require their facilitative help also.
Not even leased out your equipment.
My way bridges, all that they are there, I have not removed, and even this transportation will be done. That way bridges etc. will be utilized. May I show more second best finding below? So on basis of Annexure 1, two things are clear, that there could not be comparison between lessee and lessee because every lessee is different, sizes are different, capacity is different. So one period can be very generous for other, and one period can be very limited for others. Then this para 43 relies on second annexure. Let me show that. And I'll go to the annexure 2 of the impugn order later on after reading this para, and I'll show how this again erroneous. That further statement as enclosed under annexure 2 indicate that there was a consistent trend of domestic consumption of iron ore maintained during period April 20 to October 20. It is indicative of the fact that there was no constraint for consumption of iron ore in the market. In fact, it has been stated by the petitioner that industrial production came to halt. Unfortunately, figures do not corroborate the contention of the petitioner, and the statement made by the petitioner is not based on facts. During period from April 20 to 31st October 20, a total of 15,44,273 number of trips of material was dispatched. which comes to almost 65.59% over the previous year. During the same period, number of trips to Paradip and Gopalpur increased by 177% over 1920, which shows that the exposed to went on upswing despite COVID and resulted restrictions. This also once again proves that despite COVID-19 pandemic, transportation of mineral from leases were happening on very regular basis. This is his finding, my lord. What he is not appreciating that because of this deadline, all these persons were sending their material to Paradip. Earlier, materials were going to industry, going to some Chhattisgarh, going to Bengal. Now, most of these material are left out, dump low grade material. So they are sending only to international market, maybe to China, my lord, because India does not have that technology to use the low grade material. So all materials are going to Paradip. So because of this deadline and because of this factor, there is increase in the traffic at Paradip. So he is saying this data shows that COVID was rather better for the transportation. That is what he is saying, Lord. I'll show the annexure at this point, Lord. Annexure 2, and then I'll deal with this. That is at Milord 1 is 163. And my lord may see the columns. First column is month, and second column is inside purchase in Odisha, and then percentage of India's inside state purchase, and then outside Odisha purchase, percentage of outside state purchase, and total domestic purchase. Now kindly see, Lord, in April, the inside Odisha purchase was 29,78,000. And then this was 64%. And then outside Odisha was 16,40,000, and this is 35%. And total domestic purchase is 46,800. I don't know what is driving here, saying that in COVID this all was going very well. Then May it increased 31,31,000, and it becomes 56%. Percentage goes down, but quantity goes up. And then outside Odisha purchase is 23 lakhs. This is again percentage up, quantity up in May. And then June again, quantities goes very up, my lord. Now this situations are getting streamlined. Percentage 49.2. Outside Odisha again 44. It becomes double. And then 50. And total dispatches 87. So it increases from 55 to 87 now. Then July it is again increased, and then August there is down. So what he is saying in the annexure, and where perusal of annexure shows different story, Lord. He is saying it was going all well, but annexure shows in April, May, June.
Was these documents given to you before?
No, Lord. That is my preliminary objection, that these documents
It was one-sided virtual hearing.
One-sided, created in the office of the DDM and office of the secretary, and we came to know only with the impugn order. That was my
Only
first.
6 months time it was. What 6 month time? 6 month time is given in the act.
The act, that's the reason, my lord.
I saw that also.
12 FF was.
And there is an extra buffer, 1 month period is given to you.
Lord, I'll show how Supreme Court has dealt with this.
Yes,
I'll show that. Let me show
that is the case.
I'll show the
during the same
Supreme Court
COVID
has dealt with the transportation and lockdown.
What is the stand of the state? What do you say? What do you say about it?
That pursuant to the direction of the Honorable Court, para 39.
No, I understand, but the way it has been done, Now the difficulty, there are two aspects of the matter. One thing is that the entire basis of the judgment is these documents. If these documents were not confronted to them, they may have an opportunity to explain, as he is now doing, that even if this document is taken, this is how the trend is. So are they not entitled to have those documents with them?
Given personal hearings.
Mr. Das, giving a personal hearing on the basis of what? And then relying on a particular document which was hidden, which was kept hide into the pocket and then shown the light of the day suddenly in the judgment. These are the two distinctions. Was there any issue? Observation that these documents were really brought and was handed over to all those, or for their perusal it has been given to make an inspection? Can you show any document that they were given an opportunity to peruse this document? Because these are the data, statistical data you have collected or prepared, I mean the office has prepared on the basis of certain materials or the documentary evidence which was there. These are the compilation. From the record which is available to you. Is it not, Mr. Das?
Conclude their argument to them.
What conclusion? This is what they have said. And the entire judgment of the authority is dependent or based upon this document. These documents, Annexure A, 1 or Annexure 2. The reasons are based upon that. He says that this data would show that there has been a movement of the minerals. It is not that the minerals were not moving. The 24 mines which were really operating at that point of time, they were dispatching those materials, everything from where they got it. He got it. From the data.
But these findings were purely based on the notifications issued by the central government with respect to movement of the minerals, operation of the mining.
There are two things. One is the complete blockage of the movement, where there is a complete restriction, no movement to take place.
But there was
the second situation is that there was a restricted movement.
Yes.
Where you were not, they were not permitted to take it, because you have also given an example of Paradeep. You say that yes, we put certain restrictions because of the erratic behavior of the drivers. They were creating a congestion when the COVID does not permit any congestions to happen. So you also admit that there was in one sector, there was already a restriction which was there imposed to avoid the congestion. If that being the position, then why? So what is now a conscious decision of the government? Just tell me. We will consider on the basis of the merit. Don't worry about it on the law. Is there any possibility of removing this kind of a impasse?
By operation of that 12 HH.
I understand. Is there any possibility of the same?
2.5 years of fast travel.
12.1 FF.
But 12.1 HH has already come into.
Oh, I understood. I am talking about 12.1 FF.
12.1 FF has been rejected by the authority.
I am again saying rejected on what ground that has come. Again and again, the position would remain.
But they have, but not only.
What is a conscious decision of the government? I just wanted, are they in a position to ponder upon, give a fresh look?
Presently, I don't have any specific instruction.
Think about it. We will consider this, but think about it if there is a possibility. As a one-time measure.
Difficulties like operation of that 12 HH already notifications
Understood,
and
understood.
everything has-
I understood.
That is the.
I understood.
Well, I'll get instruction regarding.
Only visualize 12 HH was already there when the first writ was moved.
And in 2019, before expiry of their lease, that notification is also there in our counter affidavit. They were given adequate opportunity to make warehouses nearby so that before expiry of lease, at least on the date of expiry of lease, they can remove their material from the leasehold area. At least that notification was there. All of them.
There are a lot of arguments against that can be made. So if you take this plea, this is
one of
this
the
is
pleas
a
for this-
double-edged sword. It's a double-edged sword. So we do not want to make any comment on that. But only thinking is that these are the situations that has come. Can there be a second thought?
Give me 2 weeks time.
Take a plea. Let them take a decision on that. And your matter I am releasing. That's why I did not permit you to speak more. Yes, 17353 on my personal ground release. Mr. Parija knows he ought to have reminded me. He should have reminded me.
Mr. Parija knows many people.
No, that I have been consistently in many matters being releasing it. So, ought to have release on this. 17353. 21st. Yes.
Item number 35. So item 2 is released.
Yes, obviously. There cannot be second doubt in this.
Deep blue line.
21st.
May I want to bring what is the name of the
Second week of May.
Item 36.
The still weak bench can be, I'll be making a mention according.
No, you get it from the administrative side.
Item 36.
36. First item is WBC number 41877.
And that I find from the record. Is there any special emphasis on that?
Well, this has to be heard along with the third sub item 20140.
Okay.
Both arises out of one query matter.
Same person.
Same person, the third.
Who is for the other side?
State.
Are you ready, Mr. Das?
Mr. Tripathi is appeal.
Is he ready?
He was there.
You said that it is covered.
No.
What is covered?
Got confused with one order
The interim order.
with respect to the same party. An interim order was passed.
Interim order.
That writ petition was pending.
Pending.
And it is tagged to this. It is subsequent writ petition.
Subsequently, another. That writ petition relates to the issuance of Form F by revising the additional charge. And the second writ petition relates to the demand which was made pursuant to the revised amended additional charge. That is why two separate writs were filed. One relates to for
every fiction is similar to the type of fixation. I found it.
Madam, this if your lordship will see WPC number 41866
I'm not.
and 2. After the auction, they revised the additional charge.
Unilaterally.
Right.
Oh, that was the case.
Yes.
Are you ready with the matter or you want? When you have to come. Well, now I remember because you were saying that the additional charges which is there under the concession rules of 2016 is really a price which you quoted at the time of an auction regime. So they cannot unilaterally enhance that particular price, which they cannot do it. That is what your contingent.
Yes.
Now I remember.
That is the only.
If this is covered by the judgment.
So the
that you have to get back.
Keep it on 21st.
Subsequent years it will be adjusted.
21st. You just, are you aware of this judgment?
Yes, I had given a copy.
Give him a copy. Come on, 21st. We are giving.
Can it be under orders matters if you would dispose? Under orders matters.
Yes. According to the counsel for the petition.
Great.
Item number 37.
Yes, sir, my lords. Yes, and Mr. Gopal would have appeared before your lordship. I pay your lordship.
Released.
Madam.
Next week.
Released.
My lords.
Madam.
21st.
Released.
Released. Released.
Item 38.
I have served me a copy of the affidavit yesterday.
Yesterday evening was with you. Whole night was with you. Why you did not peruse?
Served in the reception. It's a copy.
Come on, 21st.
There's some time to do.
Yes, come on, 21st. Oh, that is what I am fixing all these matters on 31st. Let them.
Item 39.
On last time,
State Council Director, High Counter.
Have you received paralyzed comment, Miller, or simply follow this pattern?
It is submitted by the additional government.
Notice was issued here. Issued to the Chief Administrator Sri Jagannath Temple Administration.
Yes, what has happened?
Nobody has registered appearance on. Nobody has entered appearance on here.
Is he answering respondent?
Yes,
or
Answering respondent will be sub-collector of state to write the reply, not
sub-collector, because the.
No, it's not filing a reply. The issue which is raised, whether
Yes,
their presence, they are the answering.
Yes, sub-collector has cancelled it. Cancelled the lease, now sub-collector should reply.
Who appears for the administration normally?
Administration, Ananthan. Mr. Ananthan.
Can you bring him?
I don't find him.
Subrat.
Tell your junior.
Subrat is no more there.
No.
Tell your junior to contact him.
And tell them.
Sunshine.
No. We can record his appearance, and then.
Both of them should find out the state
available
should also find because
Sunshine may not do that. Sunshine may be available.
Huh?
She must be. Sunshine.
Sunshine.
What is this name?
His daughter
is Juliet is Sunshine.
Is a nickname or a real name? Otherwise, adjourn for 21st. If he comes, that's all right.
Item 41. Item 41. Take a side.
But may grant me 2 weeks time to file the complaint.
I have received 2 weeks extension. Rejoinder 1 week, 3 weeks.
Item 42.
And if it is for the open about 6 and 7, you must have time for finding the counter.
What?
He also filed counter.
Counter for opposite party?
6 and 7.
6 and 7. Counter by 1 week, 2 week?
2 weeks sellers. 2 weeks sellers.
Yes?
2 weeks sellers.
Why not 1 week? In between, 10 days. Rejoinder 1 week? Yes.
5th May.
Yes.
They have declared to stop it. They have implementation and supply afterwards. That is all. And it
Next year, Tuesday is a holiday, so it cannot be done. And 21st, we have already fixed many matters.